Good afternoon, everybody. This is the final session of the day, so thank you very much for sticking with us throughout our sessions. I think you're going to have a very interesting and lively panel discussion here around one of those key themes that always comes up for everybody. People don't necessarily want it to, but enforcement is always an issue that we all have to think about in the regulated markets. So to introduce our panelists, and we have a fantastic panel here today, I'm just going to start by going from my immediate left. So I'm going to start with Mr. Jon Witts. Jon is the head of enforcement at HKEX. We then, next to Jon, have Mr. Marek Grabowski. Marek is the CEO of the Financial Reporting Council here in Hong Kong. Next to Marek, we have Mr. Sean Lam, who is the senior managing director of FTI Consulting. And next to Sean, we have Mr. Wong Chi-kwong, or CK, who is the chief superintendent of police at the Commercial Crime Bureau. And finally, of course, last but not least, Mr. Thomas Atkinson, the Executive Director of Enforcement at the SFC. So I think the first thing that we should do, probably, because there are so many topics in this area that are of interest, is probably I'm going to call on Tom to sketch out for us, essentially, what we want to talk about today, what these key themes are that are currently keeping regulators busy.
Yeah, thanks very much, Will. I guess if we think about the last time we had a forum here 4 years ago, what's changed in enforcement since then? And I think you can see it from the panel members we have here. I think the biggest change we've seen in Hong Kong is collaboration among our different enforcement agencies and criminal enforcement agencies and markets. And I think that's quite new, and that was quite a purposeful strategy on our part in 2017, where we looked at our MOUs and we dusted them off, and we wrote some new MOUs, and we tried to make sure that the market knew that we were looking at conduct issues from a much broader viewpoint than simply the SFO rules, because we knew our different regulatory partners had some tools that we don't have. For example, the police obviously have powers to arrest, which can be very effective doing joint operations. So I think that's the biggest change we've seen in quite some time. I think just to give you an idea of the partnerships we have, probably our biggest regulatory partner is the CSRC, who I meet with, myself and my management team meet with twice a year, and we do a joint training, which we just did 2 weeks ago, where we work with them with, I think we had 500 of our associates at that training on market manipulation. As Ashley said today, I think how important that relationship is. Ashley talked today about other jurisdictions not being able to duplicate that trust relation, and we all talked today about these Stock Connect programs and how much value they've added to Hong Kong. We're the people on the ground that are building those relationships and making sure those relationships are followed, and they're followed in a trustworthy manner. So today we want to talk about a couple of things. I think what would be interesting is I want to talk about some of the detection problems we have doing our investigations. I'd also like to talk about just some of the investigation problems we have. And sometimes the investigation problems we have are varied, but I can give you an example. Since 2017, I think we've done 344 searches of premises or personal residences. If you think of how much data we would have gathered on each of those searches, it's quite amazing. So how does one go through that data and put a case together? So these are some of the problems we have. So I'd like to look at, when we're looking at these problems, I'd like to look at through two lenses. One is, first of all, corporate fraud, because that's our big concern here in Hong Kong. So I'm hoping the panelists will comment on some of the successes we've had, some of the difficulties we had, some of the challenges we had. The second lens I'd like to look through is accountability. So how do we make people accountable so they observe conduct rules? Again, if you look at since 2018, we fined intermediaries, I think it's $4.3 billion. Like that's a huge amount. So the question, I would like us to answer is, are we changing behavior? Are we doing our job? So that's the real question. So on that, maybe I'd turn it back to you, William.
Thanks very much, Tom. So I think, as Tom has outlined, we're going to start by talking a little bit about corporate fraud and what the nature of that problem is, and actually the investigative challenges that Tom has referenced there. So the trend of the last few years here in Hong Kong has been very much about, as we called them, the network cases. So this is sophisticated, if you like, culprits working together to extract value from minority shareholders using organized schemes, for example, the highly dilutive fundraising schemes that we've seen. And masterminds and their affiliates have essentially used different techniques in those schemes to conceal their identities. So, for example, they may have utilized many corporate vehicles and nominee companies, including even licensed brokers, to create complex multi-layer fund flows. Now that trend, I think because of the action that's been taken in the market, is receding, but the problem hasn't been eliminated. What we're now beginning to see as a more recent trend is perpetrators starting to use fictitious loan schemes to siphon off the cash reserves of listed issuers, and that can leave effectively minority shareholders with an empty shell company with no real value. And so I think with the apparent reduction in those network cases, the SFC's been paying real attention to that new trend and how we deal with that. And in these sorts of schemes, the fraudsters that we see, they're using very complex but ostensibly legitimate structures to essentially hide what they are doing. And so that's often allowed these bad actors to actually operate in plain sight until finally being exposed. And that obviously creates huge risk. I understand actually that a very large number of corporate vehicles and nominees utilized in these structures has meant that because of these numbers being so great, actually the search operations that the SFC's conducted in these cases are the largest ever in history. So it sort of gives you an idea of the scale of these operations and the scale of the challenge. Jon, I'm actually going to go to you first on this one, obviously in the context of HKEX. And what is HKEX's enforcement strategy for upholding market quality given these issues?
Sure. Thanks, Will. So corporate fraud, from an enforcement perspective, we see that the answer is prevention rather than the cure. Now, sometimes when people talk about enforcement, instinctively they're thinking about a punishment after the bad event. And so how do we get to prevention rather than the cure? And the secret is, of course, to look at what the event is that's causing the damage, but then also to look at what goes before it, and then start thinking about what you can do about that. If you want to reduce the number of fatalities there are in car accidents on the road, sure, you can punish the bad drivers who cause those accidents, but you also start looking at rules to make sure that cars are maintained properly and are in good repair. People aren't drink driving, people aren't speeding. All those sorts of things to stop the bad thing happening. And it's no different at all with companies that are listed on the exchange. Before that bad event happens, we need to make sure that the right framework is in place. And that's what the listing rules are there for. There are all sorts of requirements in there, of course, about disclosures that need to be made, accurate information that needs to be made available on a timely basis. There are all sorts of duties on directors to make sure they apply appropriate oversight. And that's where our rules can most best kick in. If you look at our cases and those that involve some sort of fraud aspect, it's very rare that it's done by one bad actor completely operating on their own. As Will says, often it's done in plain sight, or there's a structure that is ostensibly legitimate. But there's normally someone else who knew something, or someone else who saw something. Something doesn't look quite right. And that's the point where something can be done to prevent the really bad acts from actually happening. And what we're really talking about here is essentially just good corporate governance. If you look all the way back as far as 2005, the technical committee of IOSCO published a report in response to what was seen as a real issue in the capital markets around financial fraud. And it was this idea of strengthening our capital markets against financial fraud. And that followed the likes of Enron, WorldCom, Parmalat, and so on. And it picked up on 7 areas of focus. that people could look at to try and basically stop this stuff happening. And number one of those was corporate governance. And it had a particular emphasis mentioned in that about the focus on independent non-executive directors, those who are there, really there to apply that oversight on the things that are going on. And that's still as relevant today, nearly 17 years on, as it was then. And that's exactly where our focus comes in from an enforcement perspective, because we don't need to wait for the loss event. We look at how the company is operated, the amount of oversight that's being applied, and if it falls below the standard, we can take action at that stage.
Thanks, John. And I think, CK, if I can turn to you now. From the police's perspective, you're often very involved in these cases. What are actually the specific challenges you find in dealing with corporate fraud cases?
Thanks, Will. This is the easiest question, also the most difficult question for me, because every day and every month, every year, there's a lot of challenge in handling all this complex corporate fraud. My bureau, CCB, is responsible for dealing with the most complicated commercial crime, financial investigation, and corporate fraud is definitely one of our key priorities. And I must say, if you're responsible for dealing with or handling, investigating complex corporate fraud, you must be a very optimistic person, because it takes such a long time, and then every day you find that, oh, there's a pointer to your case, and then it suddenly disappears. Why? Because there's a cross-jurisdiction issue. Sometimes you can't get the evidence from another jurisdiction, because in the Hong Kong context, there's a lot of cases. They have their base is not in Hong Kong, and the accounting record is not in Hong Kong. That's the problem. That's the big problem for us. And then there is sometimes the shareholders and the CEO, or even the professional members of the entities in question are involved. So it's another challenge for us. And not to mention now we are in the digital environment. We need and we have there's a lot of digital evidence, but how can we turn it into admissible form? It's another big challenge. I think there are lawyers here. I wonder whether there are a lot of cases now can be a lot of digital evidence can be tendered in the law court of Hong Kong as admissible. I think there's a few only. I'm not quite sure about the civil court. So all these are very, very, very big challenge for us to deal with a complex corporate fraud. And then you may say you can follow the money. Follow the money is even worse, because there's no boundary for crime proceed movement. Of course, we have secure cooperation with our stakeholder, and then with international law enforcement agencies, but it still takes time. So all these challenges are just the my experience is the top one, and I think we have to the only way to deal with it is joint effort with all the agencies and overseas law enforcement agencies to solve the problem. Thank you, Will.
Thanks, CK. I guess I have one follow-up question for you. You mentioned digital assets, and you talked actually, I think there about actually digital evidence being problematic. Have you had any specific, if you like, experience using technology to help with that, or has it actually made things more difficult? How's that process been for the police?
Hong Kong police just deal with and meet with every difficulties, whatever. So we have a dedicated unit, the cyber security and technological unit, CSTCB, and then they are responsible for assisting us, supporting us to deal with all the digital evidence. And then actually we have the Hong Kong police have devised some in-house system to deal with a specific case. What I can tell you is the what we call the supercomputer. I think you all heard of, to deal with the 2003 SARS issues. We will use it, and then For example, we foresee that there will be a big problem for the financial crime, complicated commercial crime. We are now devising a financial crime. I'm not quite sure about that. It's AI on all the information acquired from various stakeholders or intelligence. And then through automation of data and analysis, we want to build up a better analytical tool to deal with the voluminous data we acquired in our daily operation. Thanks.
Thank you. And Tom, we've talked, obviously, I gave that little introduction about how these cases have developed over the last few years. What has the SFC actually learned from those cases, and how are you utilizing those experiences to better tackle the issues?
Yeah, I think as time goes on, we're getting a lot better at them. We're learning a lot on how these people operate. We've actually developed, we call our market intelligence program. And what it allows us to do is we've taken information we have on conduct within the SFC, digitized that, and then married that with external data, such as trading data or fundraising data, and who sits on what board. So we're able to draw those connections that we never could before. We could, but we would do manually, and it would take a very long time to do. So that's it's allowing us to look at things in a more schematic way, I would say. And then so I approach these cases, and now we do a lot of cases where we do them in groups, and we try to pick sort of what the most successful cases a lot quicker than we used to. So we're making those sort of hard decisions on what to close down a lot sooner now. And just to give you an example, like the biggest sort of new type of case we're dealing with are these ramp and dump cases. So this is where someone has cornered a stock. They slowly move the value of the stock up by various methods, usually wash trading, among themselves. And meanwhile, they use what we call we teachers to use social media to get someone set to purchase the stock when they're ready to unload it. The stock is unloaded. Sometimes it's shorted as it's unloaded. But these, right now I think we've got a ton of these open cases that we're dealing with, and so I think we're getting better at them. We're freezing assets. I think we froze something like $11 billion in assets. Now, those were securities, so a lot of those have gone down in value now. But we've frozen a lot of assets, so we're moving in there quicker, trying to secure the assets. But they're very, very difficult cases. And as Megan pointed out, a lot of the players are in the mainland, or can be in the mainland, and a lot of the evidence can be in the mainland. So it's having to deal with all these problems, and I wanted to return actually to Megan's panel for a minute, because when we're talking about changing market structure, Megan mentioned that a lot of the frauds we're seeing are sort of under the $1 billion capitalization level, and I think they're actually, most of them are closer to the $500 million level. And that's why when we talk about markets, we worry about the size, because I think the stocks are just easy to corner at that size, so they're highly acceptable to manipulation. So that's what we're learning. We have built some tools to deal with the amount of data we're dealing with. Currently, right now, about a third of our time is spent on looking at fund flow, and we're developing a tool right now that allows us to do that automatically and use analytic tools on top of that.
And Sean, if I can come to you at this point, you obviously work regularly with law enforcement agencies and large private organizations. What's your experience in terms of helping those organizations investigate suspected fraud and misconduct?
Yeah, thank you, Will. First of all, thank you for having me amongst all the prominent figures in the law agency enforcement bodies here. Our experience working with law enforcement agencies and bodies have been really, really positive, and I would say very fruitful. I believe in joining forces together is a really good partnership that we had. I think Tom and CK just now talk about a number of challenges that they face because the massive uptake in enforcement actions, that massive amount of data collected, they need to be analyzed properly. They need to be looked through, review, and assessed. I think in the partnership context, what private practice can contribute a very different skill set, experience, and tools. One thing I really enjoy working with our fellow regulatory agencies and bodies, the fact that they have supreme power, they have, really, for good reasons, powers in getting information, access to data, access to directors of offices of company for interviews. And I think Tom just now talked about CSRC. This is an ideal example where we're facing conducting corporate investigation involving company listed on Hong Kong Stock Exchange with operation in China. We wanted data, we wanted bank statement, we wanted information of China. That collaboration is really helpful. Then turning to another view about private practice, from our point of view, in my humble opinion, what we can offer is our commercial lens of looking into transaction. Our fact that we have a lot of understanding of strict practice. We look at things, we look at transaction, how they were structured. We offer our pragmatic view, especially when there's industry knowledge involved. Tom just now also talked about data, the volume of data that need to be analyzed. I think private practice may provide potentially some sort of solutions in terms of offering investigative technologies and tools that can tackle that problem, at least as an interim solution.
Thanks, Sean. And Marek, I think this takes us now to talk a little bit about what the FRC is doing. Obviously, in the context of all of these discussion, auditors become particularly important. How are you organising, if you like, your new enforcement function in the context of the powers that you now have?
Sure, thank you. And also very pleased to be here to contribute to this discussion. In 2020, we had our enforcement powers extended to disciplinary sanctioning, and it's limited at this stage to listed entity auditors in relation to misconduct in carrying out audits and accountants' reports for listed entities. Of course, we're still building our team. The work is still coming through our investigation process in the main, but we expect our disciplinary team to start picking up some of those cases. The role of the FRC is very much about disclosure in the marketplace, particularly around financial reporting. The integrity of that is a very key ingredient to market integrity. Misconduct in the auditor area varies enormously from relatively minor breaches of standards to relatively significant breaches of standards, which call into question the validity or reliability of the auditor's report. So those are very significant, but probably the most significant, but I would say also probably the most rare, relatively rare circumstances are where there is intentional misconduct by auditors to collude perhaps with other perpetrators to cover up or even participate in fraudulent activity that affects financial reporting. Then obviously in those circumstances, because of the risk of cover-up and so on, those are the most difficult areas for us. So this is very, very new to our functions and something that, I would say there are probably two things that are very important to us in addressing that. One is the collaboration with other agencies and regulators. And then the other is that because of the risk of destruction of evidence in these sorts of cases, it's an area where we would expect more, it would be more likely that we would take direct action to obtain evidence. Recently we carried out our first search operation, and we did that jointly with the ICAC. This is not something I guess we would expect to do very often, given the range of what we look at. It's not purely about those sorts of misconducts, but those are the perhaps the most significant things I would like to mention.
Thank you, and it's very, I think, clear to see how all of you as agencies are now working together on these cases and pooling your resources and your various expertise, which I think is good for the market to see. I think we could talk about this topic forever, but given time, we probably had better get on to our second point, and that is individual accountability, which obviously is one of my favorite topics, as many know, but I think in this context becoming increasingly important. So just again to set the scene a little bit, individual accountability has become a key area of regulatory concern, and really since the global financial crisis has been something that people have been increasingly looking at, and regulators in particular. And it is essentially a fact that many securities-related crimes and misconduct are perpetrated with a degree of facilitation by licensed intermediaries and professional advisors, and that's why auditors obviously come into focus in that context. So regulators, I think, are always mindful of firms turning a blind eye to misconduct, and in particular, therefore, of identifying where those issues might, if you like, be coming to the fore. Now, Hong Kong, and in particular the SFC, has actually been a leader in this space, being the first major market to introduce a comprehensive senior management accountability regime for effectively securities and futures firms through the manager in charge in 2017. And also later, of course, with the Form 5U measures, has also taken steps around rolling bad apples. But I think the million-dollar question, given all of those schemes, is going to be what penalties have the most powerful deterrent effect. And so, Tom, if I can turn to you first on that, in that context, you know, the SFC has imposed record fines in recent years. That's including in relation to matters like the IPO sponsor cases, obviously a couple of years ago. But there's still a big question as to whether fines alone are enough to change culture. So what do you think on that, given effectively the experience you've had so far here?
Yeah, thank you. I think with the sponsorship cases, we didn't just fine the companies. So, for example, we suspended UBS from operating as a sponsor for a period of time. I'd say the last 50-odd cases we've done from a disciplinary action, we've suspended an individual in about a third of those cases. So we look at that very carefully. I think sponsorship is a good example because I think from what I hear from Julia's group, I think we did see changes, positive changes to the sponsorship regime at the more senior levels, at the senior firms. I think at the smaller firms, we still have some difficulties in sponsorship behavior. You can see we've been bringing those cases out over the last 6 months. So hopefully that will change behavior. But it's very difficult to tell, you know, what's the secret sauce in stopping conduct and preventing conduct. Very difficult, and we put a lot of thought into it. You know, we do have the MIC regime, but it wasn't really brought in as an enforcement tool. It was really brought in so firms understood themselves how they're organized, because you know, in these global institutions, you have these matrix reporting regimes where it's not clear who's accountable for what. So we want to make sure the firms were clear, but it does assist us in enforcement. And we have brought a case against an MIC. We've got some in the pipe right now, but I mean, we've got to be pretty judicious the way we exercise that, because I mean, we're talking, you know, we're not going to bring those for simple run-of-the-day problems, because you know we are affecting someone's life when we bring those charges. So we do think long and hard. We will bring them if we feel there's been intentional violations of rules. And I guess my last thought is the criminal deterrent. You know, how effective is that? I think it can be. It's probably the most effective. It's probably the most feared. It's probably the hardest to achieve, and it takes the longest. So the question, there's that balance of, how quickly do you need to change behavior? How successful are you going to be? What's your final result going to be? And we just given the incidence of fraud in our market, we're going to continue to work with the ICAC, the CCB, Marek's group, and we're going to be continuing to bring these criminal cases, and we're pushing hard, but they're not easy, and the outcome is far from certain. But I do think it's an important deterrent that we should follow.
Yes, no, thank you, Tom. And look, I think certainly your recent MIC case people have noted in the market and are, I think, focusing on and thinking about. So that's probably having the right sort of effect. John, from the HKEX perspective in disciplinary proceedings, what for you is the most effective deterrent? Is it actually pursuit of the company, or is it directors, senior managers?
It's 100% about the individual. The company may well be a party to the action, but the focus is definitely on the individual, and that starts first and foremost with the directors. And obviously, if you think about why a company even exists as a legal entity, it's there to limit liability in certain commercial settings, to encourage people to be entrepreneurs and so on. But it would be a shame if that existence of that legal structure meant that people could hide behind it if they've done some misconduct or even a crime. So I think the right focus has got to be, if we actually want to change people's behavior and we want to change the behavior of the company, we've still got to focus on the people who decide what that company does, and that's the directors, the senior management, the other individuals, but particularly the directors. And to give some sort of perspective of that in terms of our enforcement actions, I mean, this year we've published over 30 sanctions, 30 cases, and I'd say there's about 11 of them which the company's not involved in at all. It's just involving individuals rather than the company. Or to put that around another way, that means that we've sanctioned this year about 20 companies publicly, but it's over 160 individuals, and we're not yet at the end of the year. I expect there might be a couple more before we get to the end of the year. So absolutely a focus on the individuals, because that's where we see the chance to really drive meaningful change.
Thank you, John. Well, I think those are very interesting statistics, and they give a very good picture of what HKEX is doing in that space. Marek, I mentioned auditors, and you've obviously had an awful lot of experience investigating and looking at auditors over the years. Again, what do you think the role of individual auditors is in addressing, or if you like, mitigating the risk of corporate fraud?
So ultimately it comes down to individuals, of course, but it is a balance between the firm's responsibilities, the audit firm's responsibilities, and the individuals. I would say in all our investigation cases, which we have more experience of here at the moment in Hong Kong, it's always the engagement partner, it's always the firm. There are other individuals who have responsible roles, and those individuals are also tackled. So one example of that are the individuals who are responsible for the quality control system within the audit firm. And another example of that is the person who is assigned by the firm to carry out a quality control review prior to issuance of the audit report on behalf of the firm. So there's a number of different individuals who are held accountable through our work. I think it's also worth pointing out that in order to really understand where these things are going wrong, we need intelligence. We need really good intelligence, and that's quite difficult to get at the level of individual responsibility. One of the things that we have seen pick up, certainly since the beginning of this year, and maybe inspired by some of the work we were doing on particular cases with some transparency, but it underpins the role of whistleblowers in providing information about what's going on at the ground level. And I would say that's true both in relation to listed entities in terms of financial reporting and very particularly for us auditors, of course. So that's a channel that helps us to get real information on the ground about bad behaviours. When it comes to some of the more serious, intentional conduct, of course, individuals also probably will be held to account by others rather than us in relation to the criminal acts. But there's still a role there in relation to misconduct, in relation to the audit work that they're doing. Thanks.
And do you think, Marek, in that context, that auditors are sufficiently aware of their individual responsibility in this area? Is there more work we need to be doing around that?
Yeah, the whole question of the auditor's responsibility for fraud in relation to financial reporting's always been for all my time in the industry and in regulation, has always been an area referred to as an expectation gap. A gulf, if you like, between what auditors think their responsibilities should be or are and what the public expects of them. You know, we've had a whole series internationally of big frauds. You know, we could all name them, starting with Toshiba and, you know, Steinhoff and keep going, Carillion, Luckin. But with that series of things going on, that whole question about the auditor's responsibility for fraud is being looked at again internationally at the standard setting area. And so things will come down the track, I suspect, in terms of tightening up those responsibilities, hoping again to narrow that gap. But I would say in the short term, auditors need to focus on the responsibilities they actually have under the auditing standards today, and those are very significant. Ultimately, an auditor is supposed to obtain the evidence they need to enable them to conclude that the financial statements are not materially misstated and explicitly either due to fraud or to error. And so, to me, that's a very significant responsibility. There are many things that can be picked up by auditors. One of the things I would say is auditors need to diligently perform in accordance with the standards. If they did so, some of the things that we see in investigations, you know, which could have led them to identify fraud, might have enabled them to do so. And those are sometimes quite simple things. Just two examples, and I'll pause then if I may. But one example is the number of times that we find when we're investigating something where there's suspected fraud, where we find evidence on their files that have red flags that really should have been followed through. Perhaps they're not even identified, the red flags, and it can only be down to a question of diligent performance of the work. And then the second area that is commonly seen, confirmations from third parties are a very important part of the evidence that auditors gather. And you know, in order to make sure that the evidence that's collected in that area is reliable, it's very important that proper controls are established. But very often we see that those controls are slack, not performed very well. Again, diligent work, just following the standards today, could certainly help. Thanks.
Thank you. And CK, from the police perspective, you obviously spend a lot of time looking at individuals, thinking about individuals. Do you have any insight into how you identify the person who is culpable within a large organization?
Yes, it is a very difficult part from a very large organization, how to identify the individual, culpable individual. I agree to just Marek said. I think share this disclosure, share in-information, joint effort is the key. But my experience as a police detective, crime manager, I think it's the most important is the intelligence-led investigation or operation. I can quote an example for you. In the police, we have set up a fraud and money laundering intelligence task force. We are joint effort with the banking sectors. We include the virtual bank recently, and then we meet regularly, and then we exchange intelligence on specific case. And then from that, we develop a lot of new pieces of information that we can go further, and then we can further develop into a very successful case. On some occasion, this specific piece of intelligence can help other cases, other complex fraud cases, which we never expected. And this, we call it FRIMLAT, for Fraud and Money Laundering Intelligence Task Force. There are 23 around the globe, and all advanced economy country, you name it, USA, Singapore, Canada, UK, they all have it. And then in last year, they published a report and assessing the outcome of this 23 intelligence task force. And you will not amaze because all the joint effort from the Hong Kong relevant stakeholder, we're actually on the top among this 23 task force. So definitely intelligence is the key. Back to this complex corporate fraud, I think whistleblower is the best because sometimes or most often they can produce or they can give you an admissible form of evidence to specifically target that culpable individual. That's very important because if you remember at the start of this sharing, I said sometimes, well, there's so many challenges. Sometimes I sit in the office, I don't know where to go. Where are the pointers in relation to a highly complex corporate fraud investigation? And the whistleblower will give you a very specific pointer. You develop from there. And I'm sure that that's why FLC or SFC, they have very successful cases recently or last year with ICAC and SFC with us. I think that's the key. Of course, for whistleblower, we must be mindful because sometimes there is two opposing party of whistleblowers from the same entity. So in that aspect, we must be very careful. Of course, we will examine, for other sources, we examine the board of director minutes, we will interview the auditor, and then we will see the regulatory inspection report. We will assess all the information to find with a will to identify the culpable individual. Thank you.
Thanks, CK. And Sean, if I can turn to you at this point. We've now heard about all of these investigation techniques. How do you as an investigator try to root out wrongdoers? And also, if I can ask you, what sort of challenges do you find with digital data? I'm thinking particularly just from our experiences, things like WeChat, the fact that so much of the evidence you find will be on these platforms, etc. How do you handle that?
I'm aware there's two-part questions, so I'll deal with the first bit first. I really enjoy hearing all the insight. I think what was said and shared among our panelists today resonate with what we see under forensic investigator. More and more these days, fraud are really getting more complex. They represent something like what we just mentioned, the network company cases, where people collude together. They are serious, they're very complex, they involve a cast of character, and as such, getting intelligence to answer your questions is the right thing. But more and more these days, when people are very deliberate to disguise their identity, to hide their transaction, to camouflage transaction, intelligence we take that to the next level. It wasn't just so much about getting information about people directorship, who sit on the board of a company, who was the ex-CEO or who was the ex-CFO of the companies. We're taking more of the public domain data. A lot of these are become, if I may, semi-official data, such as information we get from public industry publication, information we can get from social media, people LinkedIn profile, transactional data such as seekers data. We combine them together and identify trends and cluster. This is a really tedious task, and more these days, what we try to do is to employ computers, technology, specifically AI to do so. So the technique is getting all the data together. They're seemingly isolated, but then if we cluster it well, if we layer it well, if we connect the dots, then we're starting to see patterns. More and more these days, we do have anecdotally some examples of using AI to do this sort of network analysis to identify relationship. Then second point about WeChat. I mean, WeChat is obviously, as all the audience here today know, aware, WeChat is a very popular tool that instant messaging application that people use in China, in Hong Kong, and a lot of different parts in Asia. The challenges that we had in WeChat in the past is that different version control and also the fact that it's encrypted, meaning collection analysis is a bit of a hit and miss. You might have success in getting data, but then there were compatibility issues that stop us from getting the full pictures of what's going on. But then as WeChat is getting more prominence as investigation tools and the source of information, there are actually even off-the-street software that people can deploy to navigate this sort of issue. And other challenges that we see more is about the fact that there's a very common MYOB culture in Hong Kong and China that people uses their personal device to install their WeChat and to conduct business-related conversation. From our perspective, we are from the private practice. We don't necessarily have the same power to seize data like our regulators, our representatives. Then really come down to we getting the consent from the relevant user of the phone or the WeChat applicants. It was a challenge in the past, but then now technology is developed in the sense that we can actually go very selective to specific WeChat messages, specific WeChat messages with specific context to make a forensic copy of such data for analysis. Just give you an example. Let's say I have a phone with 5 contacts on the list. 3 of those are my personal contact, which I'm not going to let FTI touch. I can actually, with some special techniques and software involved, only allow people to take hold of what's in the conversation with the remaining 2 contacts for analysis purpose. This is not a perfect solution, but at least it's getting better response and taking the way forward.
Thanks very much, Sean. I think we're almost out of time, but perhaps we have time for a question or two. Tom, I'm going to put this first question to you. I think when we talk about enforcement, we talk about regulation, there's sometimes concern about striking a balance, if you like, between that regulation and market development. Do you think there is a risk that an overly heavy regulatory burden would affect Hong Kong's competitiveness?
I'm really, personally, I'm not. I think I get very worried when I read in the papers people commenting that we can just try these things, and if they don't work and, the companies blow up, don't worry, you can just do more enforcement and that will solve the problem. And I think, especially in a market where your evidence, your targets are in another jurisdiction, you're very dependent on another regulator to get that evidence. I think probably the most, as Megan put earlier, is probably the most important function we have is gatekeeping. And it's no good. I mean, enforcement's important. Enforcement has its place, but it shouldn't take the form of gatekeeping, and it shouldn't be a substitute for gatekeeping, because it can take us years to gather evidence. Most of the time, no one gets their money back at the end. So when that's what worries. So I don't think, and I've heard that sort of, and that's why I mentioned sort of most of these frauds are happening sort of in that lower end of the capitalization of the market, and we know that, right? So I get very nervous when people talk about let's relax, things around that area, because we know what's going to result, and I know I can't solve that problem. I know in the end I might be able to hurt someone's reputation down the road, but I'm probably going to not get those retail investors' money back, which is what they really want.
Yeah, no, I think that's a very good observation. So I think a final question, perhaps for everybody. We've talked obviously now about corporate fraud. We've talked about individual accountability, both key topics. But looking forward, it's November 2021. What do we think are the enforcement trends that you each see coming in 2022? So I'll give you 30 seconds each, perhaps. John, do you want to start?
Sure. Yeah, okay. Well, 2021 has already been a record year for us in terms of the number of sanctions that we've issued. So I think probably the first thought is that how's that going to compare to next year? It's not really about trying to hit records or anything like that, but I think the amount of enforcement activity we will see next year will continue to be very high. I don't think we're going to go back to the levels that we saw, say, 5 or 6 years ago. And in terms of the nature of the cases, I mean, I think probably one area to watch, it's something that's been touched on in a couple of the panel before, and I think briefly just in this one as well. I think we'll see a little bit more around newly listed issuers. I think it's going to be an important part of our regulatory messaging to make sure that people start on the front foot. It's a terrible shame when someone gets listed and then they straight away get themselves into an enforcement action. So I think we're going to see a little bit of a focus there.
Great. Marek?
Perhaps just echo the comment that it's going to increase because since the beginning of this calendar year, the complaints that come into us for our enforcement process to deal with, ranging from the public, whistleblowers, referrals from other regulators and enforcement agencies, have more than doubled already. And that seems to go on an increasing trend each month at the moment. So I don't see that falling back either.
Great. And Sean?
I would agree that enforcement cases are going to be now uptake the coming year, and particularly in this area of financial reporting fraud, when now we are in November, in a few months' time, companies will be very busy closing their books, issuing their audit accounts. Another observation, and I do agree with what John said, IPO listing fraud, listing irregularity would be another focus. And surely getting the IPO listing right is a very important gatekeeper.
Thank you. And CK, from the CCB perspective.
Yes, I think we must join effort among FRC, ICAC, SFC, HKMA. We must pull in all the resources, expertise, and experience to help each other. Because for a highly complex case, no single agents can handle it. And more importantly, we must share the cases as early as possible, and then capacity building for our colleagues. For example, I share some of our experience to SFC, and then SFC share their expertise with us. That's the way forward, I think. Thank you.
Thank you. And finally, Tom.
Just agree more collaboration, but 3 areas that I would say I know we have a lot of those ramp and dump cases. Secondly, corporate loan cases where directors are giving fictitious loans to or loans out to people that don't exist or they're related to them. It's almost a straight theft, but we're seeing a lot of those cases right now. And lastly, intermediaries that facilitate behavior we don't like, such as money laundering or know your client issues. And I'm talking about the situation where the truck driver has $1 billion running through his account, and we don't know where that money came, who brought that money into his account, and the intermediary isn't doing their job. So I can see some of those cases in the pipe right now.
Okay, great. Well, that's interesting, certainly particularly on the AML point at the end. Well, look, I think we are now out of time, just over time, and I realise many of you been here all day, so thank you for that. I think it just remains for me to thank John, Marek, Sean, CK and Tom for a very interesting discussion. Thank you, and thank you, everybody.